Hi, Karen. Introduce yourself, please.
I'm Karen Chris Weisbord. I'm an attorney who represents Social Security Disability and SSI claimants.
Been doing this long?
I've been doing this for over 40 years.
Tell us a little bit about this kind of practice.
Social Security Disability and SSI are complicated inquiries. Some people think, well, I can file this on my own. That is not a wise move. There are many regulations and rulings that apply to these cases. You can have two claimants with the same medical history, and yet one is successful and one is not. Your age, your work history are all factors that go into whether you will have a successful case.
But if I want to apply for Social Security, why shouldn't I try it on my own? And then if I don't win, then I get a lawyer.
There are many forms that are required from the very beginning. These forms often are used by judges and adjudicators to deny the case. The problem is that people who are disabled often do not want to focus on their limitations that affect them every day. It's hurtful, it's hard. I review every form that a claimant files so that it is clear and it is accurate and it is complete.
Does it matter whether a person has a physical problem as opposed to a mental, or is one or the other covered and the other not?
That's a good question. There are different pathways to getting disability and achieving a good result. Some people are mentally impaired, some people are physically impaired, some people are both. What is key is having the appropriate treatment record and clinical testing, if that's applicable, to support the claim.
What do you do when somebody comes in and says, I have all these problems, but I haven't treated with anybody for a while?
Well, that's of course bad medically, and it's bad legally, both.
Well, from a legal standpoint, what difference does it make to a judge whether I've been treating or not?
These are medical record-driven cases, so while a claimant's testimony is important to be sure, without the appropriate medical record, which includes the appropriate clinical testing, the appropriate specialists, then the case will likely not succeed.
So what do you do when that kind of claimant comes along?
Well, we have discussions, and what's very interesting is that claimants who are not being treated medically not only compromise themselves from a legal standpoint, but from a medical standpoint as well. To get the appropriate treatment, to have good outcomes, it's important from a physical or mental standpoint as well as from a legal standpoint. So all of those goals are served.
Somebody calls your office. What's the process? They want a lawyer. First of all, do you help with the application itself?
I do. And in fact, the best cases are people who apply with an attorney from the very beginning, because then mistakes aren't made, gaps or failures in treatment don't occur, and the case is supported. These are, again, difficult inquiries. Questions such as an onset date to allege, that can affect the amount of money benefits you win if you succeed. Many people think that the onset date is the date they last stepped foot in the workplace or the last day they were on payroll. That may be an incorrect assumption depending on the facts. You may be leaving many months on the table that you could have achieved had you had an attorney who understood the regulations. It's important not only to not do it by yourself, but to find an experienced attorney who understands all the ins and outs of this process.
So if I find you somewhere in the various searches I make and I call your office, at what point do I end up talking to a lawyer?
You will talk to me on the first phone call.
Wow. And if I'm talking to you on the first phone call, who's going to represent me throughout the process till I actually get in front of a judge?
Me and me alone. You will have the same lawyer who spoke to you at the application process and reviewed your forms to represent you in court.
And you prepare me before I go to court?
Absolutely.
I-
I not only prepare you, but although it's not required, I prepare an extensive pretrial brief for the judge in every case. This lays out the medical, vocational, and factual reasons why a favorable decision should be issued.
Well, that sounds well and good, but what's this going to cost me? How much do I have to come into the office with?
These are done strictly on contingent fee. We only get paid if we win the case, and Social Security withholds 25% of the back money, not the forward monthly money, to pay the attorney.
Is this kind of standard, or is that just what you do and some people charge differently?
No, this is standard. This is by statute.
One last question. Why should I choose you as my attorney as opposed to one of the other people that have advertised all over the place?
It's critical to hire an attorney that has experience in this specific area. I have more than 40 years of experience trying hundreds of cases and handling hundreds of applications. I was co-chair of the Philadelphia Bar Association Social Security Disability Committee for many years. I have taught classes of continuing legal education, training other lawyers how to do these cases. So I pretty much understand the rules and regulations and what it takes to bring these cases to a successful conclusion.
One last question. Back when they weren't doing all this video work and you would actually go and do a hearing with the judge live and you'd be in a waiting room, lawyers would come in and announce the name of their client and it looks like they never saw them before. I mean, can you win a case like that?
Without really knowing the client, without being involved in all the medicals and taking actions to collect all the medicals, to do a pretrial brief, to have an extensive preparation time with the client so you understand all their facts and all their issues, which I do well prior to the hearing, not on the same day of the hearing, but on days prior, so that we have all the time we need to understand what's involved. Coming in and just finding out your attorney on the day you are going to hearing or a half hour before, that does not generally lead to successful conclusions.
You ever give your clients those extensive briefs that you write?
Absolutely. It helps them focus and remember what their issues are. Often it's an overwhelming situation to appear before a judge. Now they understand and try to remember, and they've got it all laid out for them.
All right, well, thanks for